Hello, good day to you. My name is Norma Obonna. I am a legal practitioner called to the Nigerian Bar. I am based and practicing in Lagos State, Nigeria. In this channel, we talk about everything that relates to the governance of companies in Nigeria, and also as it relates to the adoption of the best corporate governance practices in ensuring that companies are run sustainably. Today, we're going to be talking about extraordinary general meetings. You'd recall that for a while now we've been talking about the meetings of companies. We've talked about the statutory meetings of companies. We spoke about the annual general meeting of companies. Now, the extraordinary general meeting is the third type of meetings that the shareholders of a company holds. Now, the provision for the holding of extraordinary general meetings of companies in Nigeria is provided for in Section 239 of the Companies and Allied Matters Act 2020. That section provides that the Board of Directors can convene the meeting of convene the meeting of the shareholders of a company at any time. Let me recap. The board of directors can convene an extraordinary general meeting of the shareholders of a company at any time. Also, where there are not enough board members to convene this meeting, any director at all can convene the meeting of the extraordinary general meeting of the shareholders of a company. That's on one side. Now, where shareholders want an extraordinary general meeting to be convened, shareholders can requisition this meeting, and the act provides, that's the Companies and Allied Matters Act, provides that any shareholders that hold up to 10% of the voting rights of in a company can convene the extraordinary general meeting of such company. And such voting rights, that shareholder or the group of shareholders that are calling this meeting must hold this 10% voting rights as at the time of requisitioning this meeting. Now, in the persons, when the shareholders while requisitioning this meeting, the document with which this requisition is being made must contain some basic things. One of it is that it must contain the subject to be discussed at the meeting. That's the object of the meeting, what they want discussed at the meeting. Then also, this document must be signed by the shareholder or the shareholders that are requisitioning this meeting. In addition to that, the shareholders or the persons requisitioning this meeting may want, what they want discussed at the meeting might be the review of certain documents or something. So they are free also to attach the documents, some documents to the requisition which they will be submitting to the head office of the company. So that leads me to the next thing. Where can this requisition be made? The shareholders who are requisitioning this meeting must submit the requisition to the head office of the company. So that document must be submitted at the head office of the company. Now, in a situation where these shareholders that I've mentioned now have duly requisitioned this meeting, and 21 days from the date at the expiration of 21 days after the requisition of this meeting, the shareholders or the directors now, the board of directors have not convened this meeting. Persons which represent one half, that is half of the shares of the right of the person who have requisitioned this meeting, can go ahead and convene this meeting. Let me break it down. So earlier I said that persons holding 10% of the voting rights in a company can requisition a meeting. Now, when they requisition this meeting, it is the duty of the directors to call the extraordinary general meeting. But in a situation where the directors fail to call this meeting, the persons who have requisitioned this meeting can go ahead and call this meeting. But it's not necessary, it's not a must that all the persons that requisitioned this meeting must all call the meeting. But persons who hold the half of the shares, let me say, if the persons that called the meeting hold, say, 10% of the voting rights of the company, 5%, the persons that hold 5% of the voting rights, which make up the person that have requisitioned this meeting, can go ahead and convene this meeting. I hope that this is clear enough. Where such a meeting has been convened by these shareholders because of the failure of the directors to do the needful, any expenses, reasonable expenses that were incurred by the requisitionists in calling this meeting will have to be reimbursed by the company to such shareholders in that instance. Now, every resolution that will be passed in any extraordinary general meeting, or all businesses to be transacted in an extraordinary general meeting, is deemed to be a special business. If you recall our discussion in the annual general meetings, you remember that I told you that the resolutions, the businesses transacted in an annual general meeting are divided into ordinary businesses and special businesses. But in an extraordinary general meeting now, every business transacted there is deemed to be a special business, because ordinarily, before an extraordinary general meeting is called, is for something urgent, is, as the name goes, extraordinary. It cannot wait till the annual general meeting. So it goes without saying that the businesses that will be transacted there are things that are very important, things that are very fundamental, things that are very urgent and cogent. And therefore, every business to be transacted in this type of meeting is regarded as a special business. And in this instance, it means that the resolutions to be passed in such a meeting are also referred to, or will be treated as special resolutions. And by the provisions of KAMA, every special resolution, notice of an intention to have such a resolution passed, a 21 days notice of an intention to have such a resolution passed must be given to the shareholders. So, in as much as this section, that's section 239, does not require that 21 days notice must be given for the meeting, but where it has been seen that a resolution will be proposed or that a resolution will be passed in this meeting, then it behoves the company, that is now the directors or the persons requisitioning this meeting, to ensure that 21 days notice of this resolution is given to the members of the meeting. Now, in as much as this type of meeting is not like the normal statutory meeting or the routine annual general meeting, in as much as it can be called at any time by the directors, the Act also provides that as much as possible, the guidelines or the provisions of the law as it relates to convening meetings, or as relates to having meetings convened by directors, all those provisions should also be complied with in convening an extraordinary general meeting, even if it is convened, even if it is requisitioned by shareholders, or even if it is convened by shareholders. Everything that the board of directors would do in convening a meeting, all those things, as much as possible, should be adopted in convening an extraordinary general meeting. This would relate to giving of notice, as I had mentioned earlier, 21 days notice, where a resolution would be passed at the meeting, or as it relates to venue. I had spoken to venue earlier in my discussions on statutory meetings and annual general meetings, and I had stressed that the law requires that the venues for these meetings should be Nigeria. I also mentioned that for small companies and for companies that have just a single shareholder, they must not have their meetings, their general meetings, their shareholders meetings in Nigeria. But every other company that is not a small company, that is not a company with a single shareholder, must have its meeting in Nigeria, and such meeting also includes the extraordinary general meeting. Also, I also mentioned at this point that as it relates to venue, just as an addendum, the annual general meetings of public companies can be held virtually. Before, in the 1999 CAMA, it wasn't possible, but by the enactment of CAMA 2020, it has made provision that private companies can hold its annual general meetings electronically, but not public companies. So this is where I would end our discussion on extraordinary general meetings. I hope that what we've shared is very relevant to you. I would implore you to please engage our videos. Please give us a thumbs up, like, comment, subscribe, share, and turn on your notification bell so that anytime we post any videos, you would be the first to know. Thank you very much to our returning subscribers, and for our first-time viewers, thank you for stopping by, and please do join our community. Do have yourselves a very productive day, and see you in my next video.